Okay, financial disclosures organized in the annual report. Currently, 1365 requires the pro forma operating budget or summary, the reserve funding, review of financial documents, all the things that you're used to. Collection policies, have you all redone your collection policies? Mm-hmm. Collection policies have got to be done for next year. You don't want to be in a situation where you're not able to collect assessments because the policy is not compliant. New code section 5300 says that the board, on behalf of the association, must distribute by individual notice. And I just said general a moment ago. Individual notice, the budget report or the summary. So even though it's going out to every member, it's one of the ones where you are required to send it by individual notice. What's the problem here? This is part of that packet that we're putting together for our annual policies, that years 5 and 11, and these are going out general. You can't do it because this requires individual notice. So unless this is going to be a smaller and or separate mailing, you're going to be pushed in to individual notice because this is required to go out by individual notice. I think hopefully that one will be clarified. To me, it seems like it's something that slipped through the cracks, but I don't attest that I have the ability to figure out what our legislature is doing. Annual budget report. So it must now include at least the following. The pro forma operating budget, same things as before. The reserve summary, and this is consistent with the new numbering 5565. The reserve funding plan summary, we used to call it reserve studies, reserve funding plan summary. Again, there's a code section that tells you exactly how it's supposed to be prepared, and you do have to provide notice to the members, and you will provide the whole thing to the members upon their request. Compliance with this is rather easy because it's very clear in the statute exactly what has to be included in that package. So label your stuff, get your documents upgraded so they're compliant, and it'll just be part of your packaging. This is only going to be painful once, I think, assuming we do it right, which of course we will. This is my first wow. I have a wow in mind. It talks about major component repair statement. This is a statement as to whether the board has determined to defer or not undertake repairs or replacements that are suggested in the reserve policy statement. So the reserve policy, formerly the reserve study, says you need to replace the heater for the pool. It's gone out, it's exceeded its useful life. If your board chooses not to do that, they have to take an affirmative action not to do that by making a statement. We're not doing that because it's working just fine and it has 3 years left on its warranty. Because if that puppy dies a week from Monday after the statute goes into force and effect, and somebody will say that the financial packet was incorrect because the board should have allocated for that cost and they weren't following the advice of their expert to change that component. So I do want us all to be very mindful of this. I am concerned that homeowners who are never satisfied with what the board does or what management does, and certainly never with what legal does, will look for non-compliance on these issues without board members outing themselves. Maybe you just need to come up with a little form that you will include in your documents, and when they get that form, say, we're not doing these 4 things, just a sentence on each. And let them sign that, not you, of course. We also have to say, pardon me, whether or not there's an anticipated special assessment. So you have to have a anticipated special assessment statement. That's what it's called. That statement is supposed to be a guesstimate as to whether or not the board, when reviewing that 30-year reserve funding plan, thinks that there's going to be an assessment, let's say a special assessment in year 18. As if we all now have crystal balls that a board is going to actually know the answer to that. Well, we're supposed to know where our funding is supposed to come from, right? We're supposed to know where that's going to be. Are we going to need a way to get through this year? That's all we can really hope for, is that we're figuring out how to get through this year. This provision requires a statement. I want the statement to be, we don't know. We don't know. I would absolutely not walk through likely, possible, or yes. Those are not good answers. It should just be, we don't know. Because otherwise, it's as if you have to calculate budgets for the next 30 years in order to be able to answer that statement in the affirmative. Yes, there will be a special assessment, or yes, there will be a need for a special assessment. Or the only other answer that I can think of is likely. It will likely need a special assessment. And how would you know? We don't know, but based on what we see, it's likely. So that's how I would do it, because I don't think it's a question that actually can easily and correctly be answered. Reserve funding mechanism statement. This is something that you're used to doing. It just has a different name. And this is the mechanism or the manner in which the board is going to take the association through the funding process for major components. Assessments, association assets, we're deferring doing the work, we're doing some repairs, some deferred maintenance, not others, or we're going to use other association assets. And so they want that disclosure. Language for the calculating reserve statement, procedures for calculating reserve statements, the same thing that you have now. It talks about you can't assume a rate of return on cash deposits higher than 2% in the Bank of San Francisco, and some of the other things. Like, that's so hard. Why would they do that? It's been the statute for 10 years. So it's not a change. It's just in a different section, and it looks a little bit more scary. Outstanding loan statement. This is the statement as to whether the association has outstanding loans. Are you doing this now? You will be doing this. They want to know what the loans are, if the loan is going to be for a term of more than 1 year. And you have to say who the payee is, the interest rate, how much is outstanding, what the annual payment is, and when the loan is scheduled to be retired. And if there are no loans, you actually have to say that. You have to make an affirmative statement, there are no outstanding loans. So don't just say, oh, there are no loans for this association, I don't have to do anything. You are required to make an affirmative statement. Assessment of reserve funding disclosure summary form. This form is prepared pursuant to 5570. It accompanies the annual budget report, and there's nothing new or big about that other than the name. Insurance summary. You're already doing insurance summaries now, right? Okay, so this is basically the same thing. It's a summary of all the insurances, general liability, earthquake, flood, the biggies. And these are the components of what information you have to provide: name of the insurer, type, policy limit, and policy deductible, if any. Did you have to do the policy deductible now? I don't think so. And I really want none of us to mess up on that, because not all of our documents are good about saying who is responsible for the damage at an association. And I'm trying to think like a lawyer here, saying, well, if this disclosure form, which every owner gets, says that the owner is now on notice that they are responsible for the deductible if they cause the loss, I'm going to rely on that statutory provision. So please help me out here and don't blow this really important section. Section 5810 on this insurance stuff, it requires members be individually notified if any policies have lapsed. So this is the second big wow, because even though this is general notice, you have to send it out by individual notice, because the legislature said in their notes, this is such a big deal. If somebody is scared that they're exposed to a liability because the association doesn't have coverage, we want to make sure this information gets to them directly. And that was the reason behind this exception, that it couldn't go out by general notice. Review of financial statements. Same thing as before, but it's under the new law, it's 5305. You have to review the financial statements, in which the gross income is more than $75,000, excuse me, and distributed to members within the 120-day fiscal year period. A copy of the review for this financial statement is delivered to the members by individual delivery. This is number 3. So they want to make sure you know the financial condition of the association, and even though it's going out to everyone, you do not get to take advantage of general, you have to send it out individual. In your association documents, this is one of the very few references where it says that your documents can provide more stringent standards for any of this criteria. What's the big deal? This is the big deal. There is a huge penalty. I started with it, I'm going to end with it. 5605 says if you fail to comply with the disclosures required under the annual budget report and distribution, and the association has increased assessments for the next fiscal year, the board will not be able to enforce that increase in assessments. That's the penalty for making a mistake. And it is a big mistake, and it is a huge penalty. But when they were going through this process, the legislature said there has to be something that's going to be the punishment to make everybody do this. And this is quite the punishment.